Good afternoon, everyone. This time, we are going to have the session on human rights as a cause of action. And to start with that, we are going to hear from the chairperson of the CHR, Attorney Richard Palpal-latoc. So before he was appointed as the chairperson of the Commission on Human Rights, Attorney Palpal-latoc served as Deputy Executive Secretary for Legal Affairs under the Office of the President. And in 2020, he was the Assistant City Prosecutor of Quezon City. He rose from the ranks. He similarly served the government in the past in various capacities, like as a lawyer at the Department of Social Welfare and Development Field Office, Region 4A, and several positions under the Office of the Ombudsman, particularly as Graft Investigation and Prosecution Officer as his last position in the said office. He also had a robust private practice career, and he is a trial lawyer and partner at the Rodriguez Esquivel Palpal-latoc law firm. So let's hear from the Honorable CHR Chairperson, Attorney Richard P. Palpal-latoc.
Good morning, Your Honors, partners from the Academy, and friends from civil society. It's always an honor to engage with legal experts, professionals, human rights advocates, as well as professors committed to safeguarding and advancing the right to a healthy environment. This is especially crucial now as we grapple with the mounting repercussions of climate change, which disproportionately affect individuals, groups, and communities already facing vulnerability due to factors such as geography, poverty, gender, age, disability, and cultural or ethnic backgrounds. It's important to note that these are the same people and communities that have historically contributed the least to greenhouse gas emissions. The global trend of driving climate governance reform through national and international laws and court systems is steadily increasing. Efforts are being made to explore and map out the potential role of legal actions in global strategies to address climate change. Climate litigation is increasingly viewed as an innovative approach for reshaping the dynamics of the fight against climate change by integrating climate rights into key legal considerations. The Intergovernmental Panel on Climate Change recognizes that inclusive strategies for climate litigation, which also puts at the core the human rights of the most vulnerable groups in society, can play a significant role in urging governments and corporate entities to pursue more ambitious climate change mitigation and adaptation goals. As the National Human Rights Institution of the Philippines, the Commission on Human Rights of the Philippines has been at the forefront of pursuing a human rights-centered approach to environmental justice and climate action. The CHRP collaborates with partners to integrate human rights into environmental laws and policies, supports the inclusion of civil society in environmental decision-making processes, access to information, and effective remedies for victims, assists human rights mechanisms in addressing environmental issues, including climate change, advocates on behalf of environmental human rights defenders, and supporting efforts by the UN system to protect them. Researches and advocates to address human rights harms caused by environmental degradation, particularly to groups in vulnerable situations, and monitors human rights situations. With a broad mandate to protect, promote, and provide policy advice on human rights, the CHRP exercised these mandates when it received a petition in 2015 calling for an investigation into the effects of climate change on the human rights of the Filipino people and on the responsibility of major oil producers, known as the carbon majors. It alleged that these companies were contributing to the adverse impact of climate change on human rights and knowingly perpetuating this phenomenon. The petition submitted to the CHR was a second attempt to present climate change as a human rights concern and the first to be acknowledged by an NHRI for investigation. Despite the lack of legal precedents and the necessary resources to handle an undertaking of such magnitude, the CHR decided to proceed with an inquiry into the intersection of climate change and human rights. Furthermore, in accordance with the UN Guiding Principles on Business and Human Rights, or UNGPBHR, it is crucial to ensure that individuals affected by business and human rights-related violations have access to both judicial and non-judicial mechanisms for redress. These non-judicial remedies should complement rather than replace or undermine judicial mechanisms. These include NHRIs, National Contact Points under OECD guidelines, and the state-run Ombudsman Office. To ensure access to non-judicial mechanisms for BHR-related victims, the CHRP conducted the National Inquiry on Climate Change, or the NICC. Upon accepting the petition, the NICC committed to conducting a transparent, open, and collaborative process that operates on the principle of persuasion rather than compulsion, thereby avoiding an adversarial approach. All parties were given reasonable time after receiving invitations to prepare and respond, and no summonses that legally obligate attendance were issued. The National Inquiry consisted of two parts: a multidisciplinary consultative process and public hearings. The inquiry panel, comprising 5 members and an independent expert, also welcomed submissions such as Amici briefs, research studies, and position papers from science and legal experts, professional organizations, academia, advocates, and duty bearers globally, addressing various aspects of the case. Furthermore, the inquiry documented the experiences of the most affected communities. The public hearings were live-streamed, allowing participation from all relevant parties and stakeholders around the world. During the public hearings in 2018, 2 sessions took place outside the Philippines, one in New York at the New York City Bar Association and the other in London at the London School of Economics, to demonstrate the inquiry panel's willingness to conduct hearings in the respondents' domicile and encourage their participation. As stated in the NICC report, public hearings conducted in North America and Europe were not only a matter of underscoring the global nature of climate change and the global character of the dialogue we sought to pursue. It was a matter of due process as well, and that is, if the carbon majors domiciled in other parts of the globe were not willing to come to our country, then we were willing to come to their regions to encourage them to participate in our processes. During the course of the proceedings, the parties pleaded asked the CHRP to dismiss the petition on 2 grounds: subject matter jurisdiction and territorial jurisdiction. Regarding subject matter jurisdiction, there was an assertion that the CHRP is only mandated to investigate cases related to civil and political rights. However, it should be noted that the right to life is recognized as a civil and political right in the International Covenant on Civil and Political Rights, to which the Philippines is a party. This is further complicated by arguments suggesting that climate change does not fall within the purview of civil and political rights. Furthermore, the Commission recognizes that it is competent to investigate the entire spectrum of human rights potentially implicated in the petition, including economic, social, and cultural rights, because under customary international law, human rights are interconnected, interdependent, and indivisible. Concerning territoriality and the authority of the CHRP to investigate activities beyond Philippine borders, there are no international or domestic laws, rules, or principles prohibiting the Commission from gathering information about facts and events occurring outside the Philippine territory, as long as it does so in a manner respecting the domestic laws of foreign territories. Moreover, the United Nations Principle relating to the status of national institutions, also known as the Paris Principles, guarantee NHRIs sufficient powers to investigate and collect information in order to fulfill their mandate to safeguard human rights. In addition to the constitutional mandate of the CHRP to investigate and examine allegations of human rights violations experienced with the Filipino people under the doctrine of competence to the competence, the CHRP has the authority to determine how to carry out its constitutional duty, and this duty is not limited by the principles of territoriality alone. On the substantial matters in the petition, the following issues were raised. 1. whether climate change is impacting the Philippines, thus threatens, impairs, infringes, abuses, and/or violates the human rights of the Filipinos. 2. Whether respondent carbon majors' actions and/or inactions are linked to climate change, thus significantly contributing to climate change. And 3. Whether respondent carbon majors are responsible under international laws and agreements and domestic laws to respect and protect the human rights of Filipinos in the context of climate change. In summary, the report finds that 1. Climate change is real. The Commission accepts the unequivocal truth as established by peer-reviewed science that climate change is happening on a global scale and echoes the findings of anthropogenic dimension of climate change. Using the data presented to the CHRP, the Commission agrees that anthropogenic contributions to climate change can no longer be denied and are in fact even quantifiable and substantial. 2. Climate change is a grave and urgent human rights concern. The NICC report illustrates how the whole gamut of human rights, civil, political, economic, social, and cultural rights, is impacted by climate change and has prevented many Filipinos from living their lives with dignity. For example, existing gender inequalities are increased or heightened by climate-related hazards such that mortality rates during times of disasters, including droughts, floods, and storms, are higher among women than men. Children have an increased risk of climate-related injuries and illnesses, as they are more vulnerable to diseases and food insecurity. Indigenous peoples are significantly impacted by climate change, owing to their dependence on climate-sensitive resources and deep cultural relationships with the environment, as well as the environment being a natural extension of their livelihood, survival, and cultural identity. Older persons are among the most vulnerable during extreme weather events because while they are able to relocate, they often contract illnesses. Older persons are also usually the last to evacuate due to their physiological needs. The LGBTQIA+ community is especially vulnerable to exclusion, violence, and exploitation, as they are frequently denied access to various social opportunities and infrastructure needed to cope with the impacts of climate change. And people living in poverty have fewer resources to mitigate the effects of climate change. They likewise face a shortage of socio-economic resources necessary to cope with climate impacts and less support from social safety nets or the financial system to recover from the impact. 3. Business enterprises are responsible for respecting human rights pursuant to various international standards, guidelines, and principles that restate and codify existing binding obligations from treaties and customary international law in the context of climate change. The responsibilities of corporations regarding human rights are further expounded in the following. 1. The UNGTBHR, 2. The United Nations Global Compact, and 3. The Organization for Economic Cooperation and Development Guidelines for Multinational Corporations. Additionally, based on the pieces of evidence gathered, carbon majors willfully obfuscated scientific findings and delayed meaningful environmental and climate action. Hence, the carbon majors contravene the standard of honesty and good faith expected of a person in exercising their rights under Articles 19 and 21 of the Civil Code of the Philippines. The CHRP regrettably acknowledges that as of today, there are still instances of denial of climate change and attempts to hinder the global shift away from reliance on fossil fuels. What is even more disheartening is that these obstructive actions are motivated not by lack of awareness but by greed. Companies in the fossil fuel industry persist in financing political campaigns aiming to impede the worldwide transition to clean, sustainable energy resources. Consequently, the NICC report outlines recommendations to different stakeholders, including the governments, carbon majors, and other carbon-intensive industries, financial institutions and investors, UN and other international bodies, NHRIs, courts, NGOs, CSOs, the legal profession, citizens, and the Philippine government. Specific to the courts, The CHRP advocates the use of litigation to compel governments to provide more ambitious emission targets, establish the right to a healthful ecology for future generations, and delineate the role of states concerning transboundary environmental harms. Moreover, the CHRP urges the court to interpret laws progressively to enhance regulation and address gaps where legislation may be vague or when current legislation is not up to date with developments in science, and to interpret the law in conformity with international obligations and act as enforcement tools of states' international obligations, including those relating to climate change. In addition, the courts are advised to grant remedies not expressly provided by laws, review government acts and compel public agencies and offices to act and revise policies, provide remedies by issuing advisory opinions through regional courts to help clarify the duties and rights relative to the environment and transboundary harms, embrace power to influence and inspire government action, exercise caution to avoid judicial review that has potential to engender administrative ossification, agency paralysis, among other phenomena. Strive to inform, determine, explain, and uphold through their decisions the rights and obligations of parties concerning particular climate laws, policies, and issues. Clarify the factual and legal basis that were found wanting or insufficient when dismissing claims to provide guidance not only to the parties but also to future actions. Take judicial notice of the findings of NHRIs and other similar bodies for the legal profession, including those working in civil society organizations, to promote and ensure human rights concerning companies. Continuously engage in strategic litigation to strengthen business and human rights norms, change public policy, increase government ambition, and create binding precedents, catalyzing the movement towards zero-carbon energy. Work towards the development of laws and legal systems that will justly protect and uphold the common interest of humankind, and lend expertise towards improving or creating a legal framework for climate accountability in their localities, which may inform and ultimately become one of the bases for the development of a global legal framework for addressing the challenges posed by climate change. The CHRP is eager to work with you to advance climate action and advocate for environmental justice. We believe that by working together, we can develop and implement effective and impactful strategies to tackle climate change. Your partnership is indispensable in our endeavor to build a more sustainable environment for the present and future generations. Good morning again, and thank you for your attention.
We are grateful for that comprehensive, substantive, and clear summary of the National Inquiry on Climate Change, or NICC, by the CHR chairperson. And we are also grateful that we have here in the Malcolm Theater Attorney Clarice Fortaleza. She is the ESRC Center OIC. So let's now move on to the reaction to the keynote of the CHR chairperson. We have here in the Malcolm Theater, Mr. Naderev, or as we fondly call him, Yeb Saño. He's a climate justice activist, and he currently serves as the executive director of Greenpeace Southeast Asia. Previously, he was the commissioner of the Philippines Climate Change Commission, the country's lead policy-making government body on climate change. Yeb was the Philippines' chief negotiator in the United Nations Framework Convention on Climate Change and was widely known for championing climate justice and the voice of the developing world in the climate negotiations. He is also the founder of the Climate Pilgrimage, and he led a 1,500-kilometer walk with other climate activists from Rome to Paris in 2015. To highlight the call to action from faith communities for urgent response to the climate crisis. So, ladies and gentlemen, please welcome Mr. Yeb Saño.
Thank you very much, Attorney Diawen, and good afternoon to everyone. When before I go into my reaction to the CHR Chair Palpal-latoc's presentation on the National Inquiry on Climate Change, which was one of the most meaningful journeys we have in the context of pursuing climate justice, not just in the history of the Philippines, but in the history of the international work on climate. Hearing my introduction, when you hear an introduction like that and you realize you've been working on environment issues, and I'm looking for Tony Oposa, for a long time, maybe more than 30 years, you feel like when you're being introduced like that and they run a list of your accomplishments, you actually feel like these are not accomplishments, because you would not have imagined when you started working in the field of environment that you will find yourself 30 years after having failed so much. Because the problems we face today are so much bigger than when we started working on it fresh out of college. So I would say my CV is filled with failure as an environmental activist. But having said that, I think we all agree that climate change needs to be called by its true name. And that's what the CHR helped us do in this national inquiry and with the outcome of this inquiry. The formal name of this process is the National Inquiry on Climate Change. It's such a mild name for what the problem really is. But it is, we also call it a legal case. We also call it a petition formally. But climate change needs to be called by its true name, and this case allowed us to do that. Because the climate crisis, it's really a crisis. It's not just some benign phenomenon that's happening in nature. It is a crisis that affects people, that affects real lives, that affects real livelihoods, affects women, children, indigenous communities, many marginalized groups in society. And what we have witnessed, we're not gonna rewind too many years ago. We can rewind a few months ago. For the very first time, my children had to stay at home and go back online, not because of COVID, but because of heat waves. Because it was so hot that the heat index in Manila was so unbearable. And we've never had that. I don't know if, I think the university also suspended or went back online, right? So my son goes to UP as well. So it has never happened in the context of our education history. It's also never happened in the context of the climate change conversation, that kids have to stay at home because it's too hot to go out there. And so climate change needs to be called by its name: hunger, famine, homelessness, collapse of livelihoods, disease, maybe heat strokes. And all of these are profound violations of human rights. And when we recognize that these are profound violations of human rights, we know what we're up against. And when we know what we're up against, our purpose is much clearer. The moral case is so much clearer. And the urgency of the issue is bolstered, not just for activists, not just for scientists who study this, but for everyone, And the climate crisis is genuinely a global emergency now. And I hope we are on the same page on that. And that is what this case is all about. It's highlighting the urgency of the climate crisis and calling it by its true name: a profound violation of human rights. So in the face of all of the realities that we hear about, the information that comes in almost every day about the climate crisis, sometimes it's so easy to be hopeless. You wake up in the morning and you hear all about these bad things, then there is a temptation. There is a very, very good temptation just to give up and say, I'll just get rich, or I'll just lead a normal life and not pay attention to these world problems. I don't like these Miss Universe questions. I hate these Miss Universe questions. So I'll just ignore them and pretend that everything will not be as bad as it would be within my lifetime. No, but that is exactly the narrative that the fossil fuel industry wants you to believe, that you cannot do anything as an individual. That was the lie that has been peddled for many decades, that the responsibility that should sit with the industry, with the fossil fuel industry, has been shifted to us. And you know this narrative, and maybe those who study torts, that if everyone is responsible, then no one can be held responsible. And that's what they're trying to make us believe, and they have succeeded. This propaganda has succeeded until the CHR ruled on this petition that the fossil fuel industry was guilty of willful obfuscation. I think willful obfuscation is obviously a very bad thing. No matter whether, regardless of whether you're a lawyer or a layman, you know that willful obfuscation is lying to people and deceiving people. And they have robbed us of an entire generation of opportunity to actually prevent this crisis from becoming a crisis. And that's why we sit here in this room talking about it as an emergency. But let me continue, and forgive me for diverging a little bit, because there's this building across the street, quite a very unpretentious building named after Carlos Romulo, Romulo Hall. And I remember whenever I look at that building and we think about justice and human rights, of course, Carlos Romulo was a big advocate of human rights. But maybe some of you know this story, because this story is well known to diplomatic circles, that in 1948, when the UNGA in Paris was assembled, this Filipino diplomat strongly disagreed with a proposal by the Soviet delegation, and they challenged his credentials, and they called him, "You're just a little man from a little country." And Romulo responded by saying, "It is the duty of the little Davids of this world to fling the pebbles of truth in the eyes of the blustering Goliaths and force them to behave." So that left the leader of the Soviet delegation with nothing left to do but sit down and shut up. So that was Carlos Romulo, and a year after he was elected as the president of the UN General Assembly, the first Asian to serve as such. And I don't know if you're old enough to have been required to memorize Carlos Romulo's manifesto, "I am a Filipino," but I want to paraphrase that a bit for our purpose today. Because he says, I'm a Filipino, inheritor of a glorious, I would add, but difficult past, hostage to the uncertain future, but also hostage to an increasingly climate-constrained and climate-unjust future. So suffice it to say, as we have witnessed through the journey, you know, the CHR case, or the national inquiry, went on we filed it in 2015, and it was resolved by the CHR in 2022, just 2 years ago. So it was a very relatively long journey. Of course, like all human rights cases go, 7 years is probably a good, relatively good. But suffice it to say that the link between climate change and human rights has been well established even before this case, but especially throughout this the course of this inquiry. And now I would say anyone who debates that, the link between climate and human rights, is either ignorant, prejudiced, or malicious, and has vested interest about this issue. Now, when we talk about the general things on what needs to be done, a lot of the conversation is around how we mitigate the climate change problem, and that means reducing emissions. The second part is adaptation, which we heard in the panel earlier today. Adaptation is how we cope and adjust, not just human systems, but natural systems, given that climate change will happen anyway. And the third aspect of it now that I'm really happy we have on the table as a pillar in the international efforts to address the climate crisis is what we call loss and damage. How we address loss and damage, because if you cannot adapt to the changes in climate or the disruptions brought about by climate change, then there are losses and there are also damages that are incurred. So that is a relatively recent recognition in the UN Framework Convention on Climate Change, in the international negotiations, that we need to recognize loss and damage, and who's going to pay for it, who's going to be responsible for it. Well, on mitigation, I would say it's a big failure. That's why this problem is not going away. It's been more than 30 years since the climate convention was adopted by every country, and the emissions that we were supposed to curb in 1992 has risen by 60% by today. So it's catastrophic, and I would say very obscene failure, especially of nations and governments to fulfill obligations that are supposed to be in these international agreements. On adaptation, it's hard to implement adaptation because there's no money flowing towards adaptation. No one will invest in adaptation. Who's gonna give money so that our agriculture is climate resilient? Who's gonna give us money so that we build seawalls? No one will profit from that, maybe except for some construction companies, but in general, there's no return on investment on adaptation, also because it's a lot of uncertainty around that, on how adaptation measures are in fact effective. And on loss and damage, it took us 3 decades to even get world leaders to pay attention to this one. And maybe you're wondering where I'm going to. So, Chair Palpal-latoc mentioned this. So it's really striking how the world is failing to address climate change. And that is why we decided to go the way of litigation. But the reason why the petitioners, including myself as an individual petitioner, and Greenpeace Southeast Asia, together with many other organizations and people's organizations, and survivors of typhoons and extreme climate events in the country, we went to the CHR. Why? Because of this frustration with the international process. And we have international agreements, we have international law we were hoping we could latch onto so that nations take ambitious, urgent action to avert this crisis and find lasting solutions. So that is why we think this is the Achilles heel of international environmental law and international multilateral processes, because it has no compliance and enforcement mechanisms. Even if you violate the UN Framework Convention on Climate Change, you get no sanctions, you get no penalties. Maybe you get shamed by civil society and NGOs and activists, but that's about it. And most, if not all, countries have violated every climate treaty, including the Philippines, I must say, because there are reportorial obligations there that we also fail to fulfill. So that's why it's exciting to think that with all this entire journey that we've had with the Commission on Human Rights, think about what a human rights-based approach to resolving the climate crisis could deliver for all of us. So the scientists and all of the advocates are telling us we need systemic and transformative changes to address the climate crisis. That means, when you say systemic and transformative changes, that means including abandoning the outmoded fossil fuel energy systems. That means, like Justice Marvick Leonen emphasized, we have to change our lifestyles. Maybe we have to change the way we look at food, produce food, and also how we move, transportation, electricity. It's massive, and ultimately it's about changing the economic system, the same system that brought us the COVID pandemic and the same system that has brought us the climate crisis. So if we look back over the course of history, a human rights-based approach, for example, has abolished slavery. It was human rights that allowed us to overcome this horror and transform that horrific, what used to be acceptable institution. And you know, when the abolitionists said we should abolish slavery, who rejected the notion that it would benefit the economy? Business people and politicians said, no, that would ruin the economy if we abolish slavery. When slavery was legally abolished, then did those economies collapse? Absolutely not. In fact, they flourished. So bringing human rights to bear, and that's what we also did with the women's movement, with women's rights that made absolutely amazing progress over many decades. So if we talk about climate change in the context of human rights, we're actually seeing a lot of remarkable breakthrough, including what we have heard from today on the CHR National Inquiry on Climate Change, because human rights provide processes and even institutions by which people can hold both governments as well as corporations to account, not just for existing commitments, but also recognizing that we live in a very exciting time when we bring this fusion. There is this amazing, beautiful fusion between human rights law, where I realize a lot of people have been working in for decades, and the climate folks did not know this, folks. And now when you combine the climate change law with human rights law, that actually is something close to what we might call a magic wand, although I would warn that there's no magic wand to finding a systemic solution to any problem. So we have a lot of work ahead of us, but it requires greater urgency. The last point I want to make, and forgive me for not touching on the essential substantive points from the inquiry because it's all written down. This is one of the most beautifully written CHR outcomes and resolutions I've ever seen, and also very comprehensive with the scientific evidence, and now it has become the largest repository of scientific evidence and community evidence. It's a combination of scientific evidence and community-based evidence on climate in the context of holding to account those who have contributed the most to this problem. I would like to emphasize that litigation is the last thing we want to do. And that's why we're excited with the human rights and climate change nexus, because the theory of human rights is that it creates obligations even without someone being sued in court. So that is really what we expect from this outcome, from this journey, from this entire collaboration with many organizations, including the CHR, because it will, our expectation is the government will bring in the necessary legislation, regulatory frameworks, take the necessary steps to address the phase out of unsustainable practices, including the fossil fuel energy system, make polluters pay, and exact accountability from the wealthiest countries because they have elevated responsibility as being primarily responsible for the climate crisis. By harnessing the power of human rights, and in particular to what our Constitution states, a right to a clean, balanced, healthful ecology, we can see the path where everybody, especially our governments, will begin to actually take actions without us having to bring them to court. Thank you very much.
Thank you so much, Thank you so much, Yeb, for giving us the petitioner's perspective of the CHR inquiry. And now, let's also hear from another environmental activist, Attorney Grizelda or Gertie Mayo-Anda. She's an environmental attorney with over 30 years of field-based practice in environmental advocacy, education, litigation, and community-based resource management in the Philippines. She established the Environmental Legal Assistance Center, or ELAC, in 1990. And it's now one of the Philippines' most active NGOs working to empower communities and local stakeholders to protect their natural resources. And she also teaches natural resources and environmental law in the Palawan State University College of Law. She received several awards and commendations for her environmental work. And the most recent was the International Recognition and Global Gratitude by the Normandy Chair for Peace in April 2023. So we thank you, Attorney Gertie, for being here today. So let's please give a round of applause for Attorney Gertie.
In Palawan, we say, mayad nga hapon. So it's great to be here, seeing colleagues. Thank you for the UP Law Center and the British Institute for International Comparative Law, the ADB, and other sponsors for inviting me. Given the limited time, I'd like to focus on what would be my take. What would be the implications to climate litigation with this inquiry. Yeb was correct in saying that it took a very challenging process to be able to achieve this. Thank you to the CHR. I was just talking to the lawyer beside me, and I said, this is really something which is groundbreaking. And one important thing that I'd like to highlight, which Rieb also mentioned, is the climate repository, or you can say climate observatory, because given the fact that you had 239 exhibits and you have 79 witnesses, 12 public hearings, there's a lot of documents and files and studies that CHR actually is the repository of. So that to me is a very important information that we need to share. In terms of the implications to climate litigation, the CHR's findings presents a roadmap for evidence. An evidence on corporate accountability, specifically on the carbon majors, building on Dr. Richard Heedy and his team on the carbon major study. It's not just evidence for the Filipinos, but also for all the citizens of the world. The recommendations of the CHR are practical, they're useful, and can be the basis of standards, collective and objective standards by which we can measure the due diligence operations of these companies. I want to quote our expert witness, Sophie Mariana, when she said that the commission's resolution provides more detail about the exact nature and extent of the obligations of states and companies to act to implement the Paris Agreement by reducing emissions and also hastening the energy transition. Now, another important implication is that the carbon majors, these are more than 50 companies, investor-owned, both state and private, but CHR, as the chairman has mentioned, the CHR mentioned that there are the carbon majors are responsible for more than 21% of the greenhouse gas emissions. So they can be held accountable for human rights violations in the context of climate change anywhere in the world. So that is important. It's great to see that they went beyond the issues of territoriality and also jurisdiction and proceeded to receive evidence. It's gratifying that the CHR asserted its constitutional mandate, and we hope that this is a groundbreaking inquiry. It can be inspiring to other groups. Other implications of the NICC report are it also opened up the stage for, in the context of the Philippines, for exacting accountability from fossil fuel companies. We do receive and listen to a lot of marketing, promotional advertisements. And the question is, can we utilize the Consumers Act? Is there anything in the corporation code that we can actually utilize in that context? There's also compelling basis for the national government, executive, and also the legislature to immediately review our Philippine Development Plan, our National Climate Change Action Plan, our National Framework Strategy on Climate Change, and also specifically include a definite plan for passage of laws and policies that strictly regulate the conduct of fossil fuel companies. For your information, there is a climate accountability bill pending in Congress now called CLIMA. And probably later, I share more about it. But the principles of the United Nations on Business and Human Rights are captured in that bill. Another implication, of course, is the need for government to pursue a communications plan that would actually, among others, share information on the human rights risk of fossil fuel companies and related business enterprises. That, to me, has yet to happen, because what we see every day are promotional materials from these companies. It's also important to take a hard look on the development plans. So it bothers you, like where I work and where I live in the beautiful last ecological frontier, the province of Palawan, there are still plans to exploit oil in fossil fuels around the province, okay? And therefore, it's important to revisit those plans. The Department of Energy, the Philippine Development Plans, NEDA's plans, how can they take into account, serious account, the NICC recommendations? As mentioned by CHR in its recommendations as well, the judiciary must be involved in reviewing evidence related to human rights risks and damages caused by businesses and corporate entities. This, hopefully later we can talk more about this, but I think it's a good recommendation. The chair mentioned about that. And for the civil society, I think it's important that a long-term and short-term advocacy agenda must be done, not only on the national level, but in provincial level, even municipal level, even barangays, most vulnerable to the impacts of climate change. You've seen the Nagat Islands, Surigao, even northern Palawan, even the central Palawan was devastated by Typhoon Rai, Odette. What can be done in the local level? Can the comprehensive land use plan, can the local disaster risk reduction and management plan respond to that? And then just to continue, in terms of insights, I've mentioned that the NICC was groundbreaking, despite the fact that it was a non-judicial process. As I have mentioned, human rights now in relation to climate change is a very important area of work, and because it provides a roadmap for evidence, then we can actually consider all that is articulated in more than 160 pages of the CHR resolution. Despite the fact that it's recommendatory and the CHR has no power to prosecute these corporations, the evidence, the factual, scientific evidence, the fact that they underscored that climate change is real, it's anthropogenic, and it's a human rights issue. The fact that they said that these corporations had early awareness, knowledge, and notice of the impacts of their businesses, but they continued to explore oil all over the world. I think that is a very important finding. And then the study of Dr. Richard Heady, and that was complemented by other experts. This actually provided factual basis for the CHR to actually look into the scientific aspects. And then the commission saw the responsibility, the duty, and the obligations of the carbon majors. It's also an insight to underscore the very challenging process of conducting community consultations, legal research, meeting with experts. To me, I've not seen that, in modesty aside, in more than 30 years of work. But it was done. It was done in Surigao, in Leyte, in several parts of Luzon, even in the area of Quezon, that island in Alabat, was it? So the communities there were able to convey their own experience, and these were things that they were not able to convey to a court of law or to a government agency in more detail. So the fact that that was considered and captured by the commission as they did the hearings and prepared the resolution is something to emphasize. Jurisdictional and territorial issues did not actually stall the inquiry proceedings because of the assertion of the CHR's mandate. And I think a few more points. Because the CHR was, I think, the first national human rights institution. Well, there was I think Commissioner Cadiz mentioned in the resolution that this was a second investigation, but it was the one which was completed successfully. But the role of national human rights institutions in investigating human rights impacts on climate change is something that can be replicated elsewhere in the world. Also, outside of court that citizens can seek redress and also provide evidence for future legal actions. The value of networks. We are part of the environmental climate justice movement. Environmental activism really has a role, and that consolidation, that collective power of citizens all over the world contributed to a lot of the evidence. It's also heartening to note that this decision and the efforts since 2013 contributed to the growing global movement for climate justice. And for civil society, and even for lawyers, prosecutors, and judges, it would be important to pursue and complement government's communications plan with their own information education agenda. People, in fact, in the interior areas who are suffering from extreme weather events or slow onsets, actually do not have a good idea about this case. So it would be good to do that IEC. Meetings with legal groups need to be pursued, even roundtable discussions and workshops to take a hard look into our rules of procedure for environmental cases and possible legal actions. So thank you for listening. Mabuhay, mayad nga hapon.
Thank you so much, Attorney Gertie. Now let's listen to the last reactor, Attorney Raymund Marvic, or as we fondly call him, ICE. Si Baguilat is an indigenous Tuwali human rights lawyer from Ifugao. He is the head legal officer at the University of the Philippines Law Center, Institute of Human Rights, and lead researcher of the Indigenous Peoples Law and Policy Program. ICE is also a senior lecturer teaching Indigenous Peoples Law, Property Law, and Legal Ethics in the UP College of Law. Outside academia, he also serves as a litigation lawyer for Indigenous Peoples, corporate secretary for the group Alyansa ng mga Abogado ng Bayan, and a trustee of the international NGO Indigenous Peoples Rights International. Ladies and gentlemen, Attorney Ice Baguilat.
Good day to everyone. It's nice to be here. While they were very positive with their comments earlier, allow me to curb some enthusiasm regarding the report, given the effects and answering some questions relating to the report that was provided and shown earlier. So, the question that we wanted to ask, coming from indigenous peoples, coming from those on the ground, would always be what happens next after this report. And it was very critical for us to look at what really happened from then until now. Because what we felt was that, while this was very much groundbreaking, several of the integral requirements for you to have a successful climate change litigation was very much lacking. For indigenous peoples and most of the marginalized groups throughout the country, one of the bigger issues would always be access to justice. For indigenous peoples, supposedly by mandate, we would be represented by the National Commission on Indigenous Peoples. When it comes to issues relating to or legal considerations relating to indigenous peoples by law, through the Indigenous Peoples' Rights Act, we should be represented by the National Commission on Indigenous Peoples. Unfortunately, when we try to talk about litigation and climate change, the common concern and refrain coming from the NCIP is that they are not really forwarding a particular position. Rather, they are just mediators. And that's a big concern. Why? Because most of the issues that are faced, particularly when dealing with climate change, is that we're dealing also with development aggression. These are all committed by the carbon majors. These are all committed by various entities, and in this case, the companies who have these various projects, including the energy projects, who are now being mediated with the help of the NCIP. So without proper access to justice, no discussion about climate change litigation would ever be successful. Second, even the right to knowledge is needed as of the moment because that is not being provided. There are some actions being committed, and thank you, Grizelda is here because they are the ones in charge for indigenous education and going to the communities, teaching them about their rights, and also other state universities. But this is very much lacking, and I will talk to you about later about the problem, why this is a problem too. The right to knowledge is very important for you to start with anything relating to litigation. How can you know about your cause of action? How will you know about how to go against these entities if you don't know the right to begin with? A cause of action would always have to begin with knowledge of your rights. And for these indigenous peoples, for those who are marginalized, most of them don't even know their rights because this is not being made apparent to them, and the government has failed in its duty to relate to these individuals, to these marginalized groups, that they have these rights that they could always ask for, that they could always demand from the government and from these private entities. More than that, moving to litigation, we should always recognize what will be the issue when we try to go to litigation. First of all, the problem is that we're already looking at the existing violation. For indigenous peoples, the problem is it starts with the failure to recognize free, prior, and informed consent. And what is free, prior, and informed consent? Free, prior, and informed consent would provide that indigenous peoples would have this innate right for being indigenous. For them to follow this process wherein, first of all, they're being given free, no coercion in any way to discuss about whatever project, whatever will be done in their ancestral domains. Prior, any project, before any activity will be done, it should be told to the community and their consent should always be asked. Informed would mean that the complete discussion should always be provided. For indigenous peoples, our problem is that we have a language barrier. Most of you would know English, but for indigenous peoples, particularly in those in geographically isolated areas, they follow their own language that is not necessarily followed or known by whoever would be the project implementers. And that's a big concern. And more than that, even it's being interpreted, there's a concern regarding its interpretation. For everyone here, would you even understand what 10,000 cubic feet would mean if you would try to change a project? How big would that be? Anyone? 10,000 cubic feet, would you have an idea? So imagine if you are an indigenous person and that would be presented to you to be part of a project. Would you really understand it? The concern with the free prior consent as well is the last portion. What does consent really mean? They forget that it should mean that there should be consensus coming from the community. And this is not being respected. For you to even go to litigation, we could prevent that to begin with if we follow a proper free, prior, and informed consent process. But unfortunately, that is not being done. And what will happen if we encounter these concerns? First, the problem with participation. To begin with, in the creation of the report, this would not have been possible, or participation coming from indigenous peoples would not have been possible without NGOs, without CSOs supporting us. And that in itself is a big concern. Why? Because currently for NGOs and CSOs supporting indigenous peoples, most of them are starting to be red tagged by the government. And for some of those indigenous communities that we have supported, unfortunately, as a narrative, we were told that when they invoked their rights because they attended one of our seminars, they were asked, bakit? Komunista ka ba? Participation in itself would always be a problem if you have those narratives, if you know that these are being told to indigenous peoples and to other marginalized groups. And this is also considered, for example, when you're talking about union members who are now facing problems about red tag, who are also facing problems regarding red tagging. No? Second, the concern regarding the proper executions. Well and good, if we will be successful when it comes to litigation, how then will we move for the execution of a judicial award? And I know this is a problem too in Palawan right now regarding the writ of kalikasan. They got the writ of kalikasan, but unfortunately our discussion with the community is that it's still continuing. What then can be done when it comes to execution? Okay. Third, the problem with the representation coming from legal groups. Okay. Usually we go to communities, we talk about rights, we talk about what can be done, we talk about writs. The last question coming from the community would be as simple. Uy, maganda po yan, pero pwede po ba na kayo yung abogado namin? Okay. And what will be the answer coming from the state university teaching them? Usually, I'm sorry, our mandate is limited to teaching. Imagine how that affects the enthusiasm of the community. Right? So, there should be a better way for us to look beyond the report. No? Litigation should also be us or organizations coming together in support of indigenous peoples group. Coming from the judiciary, and I was telling members of the Supreme Court when we had the chance to talk about some of the rules, no? But more in line with the sign language, that it's very important for us to always look at the possibility of there being a clear and fund that may be used by these organizations, because at the end of the day, we're talking about representation that will cost these communities. We're talking about representation whereby it's not just enough for you to have volunteers on the ground. This would continue from the start of filing a case up until the execution, and making sure that this would be respected afterwards. You would have to make sure that all the support would be there. Okay? So, just to wrap everything in relation to the report now, we have to be realists about it as well. It's well and good. It's being celebrated throughout the world. But at the end of the day, you're still looking at the people who are suffering. You're still looking at representation. You're talking about just transitions, but there will never be justice when the voiceless are not empowered. You're still not being to give them justice when you're not able to give them an opportunity to talk on the same level with others. With that, thank you very much.
Thank you so much, Attorney Ice, for that reaction from the perspective of indigenous peoples. And now, may we ask the representative from CHR, Attorney Clarice, if she would have some feedback? Right, thank you so much. So, ladies and gentlemen, Attorney Clarice Forteza from the CHR.
Good afternoon, everyone. First, on behalf of the Commission on Human Rights of the Philippines, of course, we'd like to thank the UP College of Law, Attorney Mike Yu, and of course, the British Institute of International and Comparative Law for giving the Commission on Human Rights of the Philippines the space to discuss the groundbreaking national inquiry on climate change. Of course, we also thank the Reactors for their support in stressing the importance of the process in establishing the nexus of climate change, business, and human rights. I'd also like to expressly mention that it was the former commissioner, Attorney Roberto Eugenio Cadiz, who is the founding president now of the Climate Action Human Rights Institute, who actually headed or led the panel inquiry on the National Inquiry on Climate Change, and we are very grateful to him for pursuing the investigation. As already highlighted by the previous reactors, the NICC process is not a judicial process, and since the CHRP, like any other national human rights institution, does not have any adjudication mandate, the NICC report is not binding or it's not enforceable against the parties involved. But the report has definitely precedential value, as already shared by Attorney Girlie Mayo-Anda. And let me highlight the three following points. First, on public accountability. The reports of NHRIs, just like the Commission on Human Rights of the Philippines, on the assessment of the state's human rights situation are heavily relied upon by the UN system and the international community. So basically, the NICC report puts pressure on the duty bearers to comply with their obligations to human rights, particularly on the United Nations Guiding Principles on Human Rights, and now the right to a clean, healthy, and sustainable environment. Second, on public awareness. The report could be used as an advocacy tool to raise public awareness, mainstream the nexus of climate change, business, and human rights, and of course, magnify the adverse impacts of climate change to the disadvantaged, vulnerable, and marginalized sector. On policy and legal changes, since the report is evidence-based, as we shared earlier, we conducted several consultations here and abroad. This could be used as an authoritative source of information for policy and legal changes. In fact, the NICC report is now being used in several European courts to establish the adverse impacts of climate change to human rights. And the report has also been cited in several official publications in UN, particularly in the United Nations Environment Program and the UN Office of the High Commissioner for Human Rights. Allow me also to elaborate on the willful obfuscation issue. So in the report, we said that the fuel industry, including the carbon majors, engaged in measures to convince the public that the use of their products would not lead to significant harm. This was done through a combination of actions. And based on the resource persons and pieces of evidence submitted to the Commission, the CHRP agrees that the carbon majors, directly by themselves or indirectly through others, singly and or through concerted action, engaged in willful obfuscation of climate science, which has prejudiced the right of the public to make informed decisions about their products, concealing that their products pose significant harms to the environment and the climate system. And all this have actually serve to obfuscate scientific findings and delay meaningful environmental and climate action. So why did we actually say that it was willful? Because the carbon majors had early awareness, notice, or knowledge of their products' adverse impacts on the environment and climate systems. In fact, their scientists, including those employed by the carbon majors, already knew about the harms that carbon dioxide from fossil fuels posed on the climate as early as 1930s, with 1965 being the latest year that the fossil fuel industry claimed ignorance of such knowledge. So does this mean that the global oil giants are responsible for spreading climate change disinformation? The answer, of course, is yes. Access to environmental information is crucial in the exercise of the right to a clean, healthy, and sustainable environment because, as we know, that's actually one of the procedural requirements under the right. And people and communities actually, through the access of information, will understand the changes and risks in the environment around them in the way that will reduce harm for very real and tangible effects of climate change. So, of course, when they are able to access information, they will likewise be able to participate in decision-making processes essential to climate change mitigation and adaptation, and hold duty bearers accountable for their actions and or inaction. So this was actually highlighted earlier by Atty. Baguilat. And then what legal action can be taken against these polluters? So in the report, we highlighted that an argument can be made under the Philippine law that acts of obfuscation, deception, and misinformation are, as described in the report, contravene the standard of honesty and good faith expected of a person in the exercise of his rights, as specifically provided under Articles 19 and 21 of the Civil Code of the Philippines. Aside from the liability anchored on acts of obfuscation of climate science, fossil-based companies may also be held to account by their shareholders for continued investments on oil explorations for largely speculative processes. Such reserves may, in the global march towards renewable energy, end up as stranded assets. and failure to comply with specific administrative or regulatory requirements, such as those in the nature of exacting transparency in business operations, may also be basis for establishing liability. Therefore, the carbon majors have the corporate responsibility to undertake human rights due diligence and provide remediation under the UNGP-BHR. So on the issue of the time that was the years that took CHR to resolve the process. As you may know, we conducted various consultations. The process was actually in multidisciplinary approach to ensure that the process is non-adversarial and that we are conducting it in a fact-finding nature. The inquiry panel was actually constituted of 5 members, led, as mentioned, by Attorney Roberto Eugenio Cadiz, and there was 1 independent expert. And we also, of course, welcome submissions from scientific and legal experts, from academe. We also admitted research studies, and all this information, all these submissions are now in the Climate Change Observatory, which you can actually access online. On our ways forward, of course, after the release of the National Inquiry on Climate Change report, we of course saw the importance of mainstreaming the key findings and recommendations under the NICC. And so the Commission on Human Rights conducted several learning sessions with different stakeholders, including national government agencies, with the academe, and also with the business sector. We have also been actively participating in the consultations being conducted by the ASEAN Environmental Group on in drafting the ASEAN Declaration on Environmental Rights. And in fact, in the latest version of the declaration, we actually highlighted that it is important to stress the free, prior, and informed consent of indigenous peoples, and that there should be provisions actually protecting and promoting the rights of indigenous peoples. Because in the current draft, it seems that many ASEAN states are not comfortable with using the term indigenous peoples. And so we highlighted that all ASEAN states are signatories to the United Nations Declaration on the Right of Indigenous Peoples, and so they should include provisions protecting and promoting the rights of indigenous peoples. We are also currently advocating for the adoption of a regional human rights framework addressing transboundary human rights issues. So we, in pursuing the NHRI inquiry mechanism, we actually built on the successes of the National Inquiry on Climate Change, considering the global nature of climate change. And so we see the importance of creating an NHRI-based cooperation to address the transboundary human rights issues in Southeast Asia. Because while we have the European Courts of Human Rights, the African Peoples and Human Rights Court, and the Inter-American Court of Human Rights, we still do not have that kind of judicial mechanism within Southeast Asia. And so we see that the inter-NHRI inquiry mechanism that we are advocating would actually fill in that gap in terms of protection of human rights within Southeast Asia. Again, as mentioned by our chair, of course, collaboration is very important so that we can move forward in terms of our work in climate action and just transition. And CHR is always welcome. We always welcome partnerships and collaborative work so that we together we can actually promote human rights, especially in the context of the environment and business. Thank you.
Thank you so much, Attorney Clarice, and also thank you to the CHR chairperson, Yeb, Attorney Gertie, and of course, Attorney Ice for the very informative session. And